The next discussion that we take forward is to understand what are the various types of deeds that are there. Now, if you look at it, this is more of a generic understanding of the different kinds of deeds. The first one being a good deed. Now, if you look at it, a good deed is something, it's not just necessary that it speaks about the style of paper, the drafting, and other aspects. It is something that conveys a good title and not one which is merely good in form. I'm not meaning the particular form of the contract, but rather I mean the substance of the particular document that is being drafted. A good deed refers to one which is complete in all aspects. It is complete in the aspect of the facts. It is complete in terms of the law. It is complete in terms of the interaction between the law and the fact in form. So this is a particular aspect of a good deed, because a good deed is like running a electricity circuit. If there is a break in the circuit, will there be a free flow of electricity? No. Similarly, if there is a break in the chain or a particular deed or a document or a contract, the contract cannot be fully performed. So as such, it is necessary that in order to be good, it needs to be complete in all aspects. There should be successful transfer of title or any other particular conveyance that is being done in a particular document. Inclusive deeds. Now, like a good deed, inclusive deeds are those which actually have designated boundaried lands which are expected from the operation of the deed. Now, if you're going to look at it, there are certain aspects that are included within the deed, and that is a particular premise which makes it an inclusive deed. A latent deed. Now, if you look at the concept of a latent deed, it is something like, say, for example, a will. Generally, a will is usually kept hidden. It is not disclosed that there is a will in existence until the death of the person who has drafted such a will. So in those circumstances, it also becomes a latent deed. Now, let me tell you, friends, this particular distinction that we are looking across is just a particular understanding of the various kinds of deeds that you will find across. And when you're introducing a particular document before the courts as to how it can be introduced is what the premise is. Then the next is a particular aspect called a lawful deed. Now, if you look at it, a lawful deed is something that conveys a good or a lawful title. Now, if you notice that there are not much of a difference between a good deed and a lawful deed. But nonetheless, a particular good deed, even though it is particularly well drafted and it conveys good title, merely because of certain aspects of illegality, it can become an unlawful deed. The next aspect is called pretended deed. A pretended deed is something that on the face of it looks to be valid, but when you go into deeper analysis, it looks to be invalid. A classic example of a pretended deed is your employment bonds. Majority of the employment bonds that you execute are something that cannot be enforced, especially with regard to the non-compete clauses or your restriction from the employee from leaving the employment. Now, these on the face of it, it looks to be good in form, it looks to be, drafted well. So in those circumstances, you feel that, there is it looks to be enforceable against an employee if the employer says you cannot join my competitor. But please look at it, it is only a pretended deed. It is just used as a means to scare the employee to ensure that they do not refrain from carrying out their duties. But if you look at the position of law, which has already been discussed in our previous classes, Section 27 of the Contract Act makes it clear there cannot be any clause which is in restraint of employment. So your non-compete clause only applies to those who are working as partners but not as employer and employees. So that is the particular aspect that you need to keep in mind to understand what is a pretended deed. And lastly, this is also a particular aspect that is called a voluntary deed. Now, what is the difference between all of these? Now, here a voluntary deed is something that is executed by both the parties. Now, you must have learned when in the initial classes of drafting of a contract that consensus ad idem, meeting of the minds is essential for going ahead with a contractual agreement or a transaction. So in those circumstances, parties come voluntarily and execute the particular contract. There are certain involuntary deeds also, where the second party is not at all given an opportunity to look into it. It is drafted involuntarily, and if he wants to take the benefits out of it, he can take the same. Examples of involuntary deeds are your gift deeds, wills, and others. Now, with this, you quite get a particular generic understanding of the various types of deeds that are there. And with this, we move on to this next aspect called parts of a deed. Now, if you look at a contract, a lot of times it scares the reader because the contract starts with extremely difficult phraseology. It has multiple parts to it. There is some introductory part on the top, and then there is some witness clause in the bottom, and there are schedules, there are annexures. You quite literally don't understand as to how to go about reading a contract. So that is the reason we are going to have a discussion on what various parts of a deed are. The first aspect, if you look at it before the clauses start, okay, right from the particular this agreement, it could be a service agreement, it could be an employment agreement. There is a title that is given, and after that comes a description of the particular agreement. Now, if you look at it, this dash agreement, this employment agreement is executed as on such and such date by and between so and so. Now, this is the description of the entire deed title. So it means that you are kind of communicating to the reader what the premise of the agreement is, who the contract is between, is what you are trying to convey. The place and date is included with this description. So wherein it is quite essential to understand that you are recording the presence of a party at a particular place. Please note, the plea of alibi is something that can be taken against the place and date of execution of a deed. So in case you are executing a deed on one date and going to insert another date in it, please note, tomorrow you are just giving across chance of an ambiguity in interpretation or implementation of the contract, because a plea of alibi can be taken by a person stating that on such and such date he was never within that place. So as such, entering the place and date of execution is also extremely crucial in a deed. The next one is the description of the parties. Now, like I told you, the description of the parties has the name of the person, the name of the father, the age of the particular party as on that date, and the address in which he resides. Now, this is a particular description which is mandatorily, and it is not any law that mandates this custom, but it is a practice that has come about. So it is a customary practice of describing the parties using their name, their father's name, and others. So as such, it becomes essential to make it a part, because identification of the parties becomes easier when you go about this format of description. Recitals. Now, this is a part where, in the contract or in the document, you will find it generally starts with the heading, whereas parties. Okay. So it says that whereas the parties have come together to, purchase and sale of a particular immovable property situated at. Now, this is a form of a recital. There are multiple clauses where the recitals are included, which can be taken into consideration to understand what the entire transaction is of in a sum and substance. The next clause that you need to keep in mind is something called a testatem clause. See, now these parts of the deed are sometimes, obsolete. They may be there in current date contracts or not, but if you essentially follow all of these particular premises, it allows you to make a good draft which has a particular premise. Now, generally, if you look what a testatem clause is, it starts with the following phrase in a general parlance. Now, this deed witnesseth that, for lawful consideration of which is accepted by the parties hereto under agree as follows. This is a particular introductory phrase which speaks about the valid consideration that is received, and that the parties are agreeing to the subsequent clauses which are there in the contract or the deed. Consideration. Now, this is also part of the particular contract where sometimes, due to oversight, consideration clauses left out. Now, if you look at the purpose of a transaction, the whole purpose of premise is the consideration itself. If you fail to include the aspect of consideration in clear terms, as to what is the exact amount that is to be paid to a party or anything, then in those circumstances you are leaving it out to ambiguity. Receipt clause. Now, it may so happen that prior to entering into a contract, there is already certain transactions that have taken place between the parties. Sometimes, like say for example, in case of sale of an immovable property, it may so happen that the keys to the particular property has already been received by one of the parties, and as such it might be required to be stated as to what are those things that are received and what are those things that will be transferred in the short due course. Operative clause. The operative clause generally tells you what is the term or duration of which the contract continues to operate. Now, like say for example, in case of a rental agreement and others, you might have noticed that in most circumstances, rental agreements are for a period of 11 months. Now, why is it so? Because the moment you make it more than 11 months, that is 12 months or more, there is a requirement or a mandate for you to register such agreements. So, as such, generally on a common parlance, you follow that rental agreements are kept for an 11-month period, or the operative clause is generally restricted to 11 months, so that you avoid the aspect of registration. Description of property. Now, in case the agreement relates to a property which is an immovable property, then description of such property becomes essential. So you use north, south, east, and west to describe the location of the property, the surrounding properties situated close to it. Like say for example, if there is a plot of land which is adjacent to the road, then you would describe the property number having survey number so and so, situated at the address, having road on east, property number X on the west, property number Y on the south, and property number Z on the north. Now, this is the manner in which you go about describing the properties using the sense of directions. Parcels clause. Now, generally, this parcels clause is essentially requirement, especially when you are dealing with the sale of immovable properties. Now, sometimes what happens is that there are certain fixtures or certain other aspects that are stuck to the land. Okay, land generally includes everything that is affixed to it. But it may so include that in case you don't add a parcels clause, you are excluding certain aspects that are affixed to the land. It could be the trees, it could be a certain machinery or any other aspects. So as such, using parcels clause is something that is very essential to make you understand as to what is being transferred. Exceptions and reservations. Now, this is a particular premise wherein you can create an exception to the contract and you can have certain reservations also. Like say for example, you must have heard about these rights called rights of first refusal. In the previous instances, you must have discussed about the Zahir Khan case, where and the W. Rooney case, wherein there was a right of first refusal that was given to the advertising agencies against the sports player. Now, in those circumstances, what do these reservations do? These reservations create a preemptive right in favor of those persons against whom it is granted. In the sense that, like say for example, there is a split of ancestral property between 4 brothers. It may so happen that one of the brother tomorrow wants to sell the land to another person. The right of first refusal can create a right in favor of the 3 other brothers to ensure that they are given a preemptive right to purchase the land before it is being sold to a third party. Now, those are the aspects that, one of the manner in which a reservation can be created in a contract. The next aspect is your premises and habendum. Now, these particular aspects have, whittled over time, and as such, having an habendum clause is seen to be, something that is more of a traditional form of a contract, and which you might not follow in the recent or modern forms of contracts. Covenants and undertakings. Now, please note, whenever a contract is executed, there are certain understandings that the parties have. One such aspect is that each party agrees or takes an onus of doing a particular action. Now, in those circumstances, these covenants need to be upheld to, and there are certain undertakings that parties take. Like, say, for example, in case of safekeeping of the goods, one of the party may undertake to ensure that insurance cover is taken on those goods that are being safe kept. Now, this is an undertaking that parties agree over and above their usual course of performance of the contract. Covenants. Like, say, for example, certain covenants are essential when you are getting into a transaction. Like, say, for instance, in regard to sale of a property, it is essential for the parties to covenant that they have lawful and valid title to transfer the agreement. Like, for instance, there could be a property where I have taken a loan, but however, this particular loan is something that is not registered. But there is an agreement to the contrary that says that the person to whom the loan is given shall not sell the property. Now, tomorrow, I am a lawful purchaser of that property, and I have a covenant clause which says that there are no restrictions on the seller to sell such property. In those circumstances, before the courts of law, my interest will be protected as a purchaser, because the person selling me the property has undertaken a covenant that he has lawful title and all rights to transfer such property, unlike how it is put across in the loan agreement with the lender. Testimonium clause. Now, testimonium clause, generally it is taken into consideration to have witnesses for a transaction, so that tomorrow, in case there is a dispute between a party or to the contract, there is a person who comes across and says that yes, I did witness them entering into a particular contract. Signature and attestation. Please note, signature and attestation are something that is generally carried out in every contract. Sometimes those who do not have proper literacy, they prefer to attest with their thumb impression, and that is also a valid attestation and a signature. And certain other documentation, like, say, for instance, when documents are executed at different places, like one of the signatory is in Bangalore, the other signatory is in Chennai, or say, let us say, in certain other jurisdictions, like, say, a foreign country also. In those circumstances, there might be a requirement for you to have the document further attested. Like, say, for instance, attestation through by means of a notary, so, or a gazetted officer. In those circumstances, what happens is attestation of such notary gives across a fixture or an increased validity to such documents, because every notary makes a book entry of a document that he attests to. So that gives you a clearer picture that a document was executed between the parties at such and such places at different times. Next premise in a parts of a deed is also referred to an endorsement or supplemental deeds. Now, it may so happen that contracts can be assigned to other persons. In those circumstances, certain endorsements are made wherein a third person steps into the shoes of one of the parties of the contract to perform the contract. Now, this could be done also by way of a supplemental deed or by mere endorsement itself. And there may be certain other scenarios where a contractual term requires to be amended, and as such, a novation of the contract takes place. A novation of a contract is essentially a supplemental deed, and it may so happen that the parties no longer want to carry out the contractual relationship and may also execute a contract for termination, and that is also in the form of a supplemental deed. Lastly, we come to the aspect of annexures or schedules, and this is also a particular essential part of a contract. I've already described to you as to what are the contents that an annexure or a schedule can have. Essentially, those things that do not make a substantial change in the legal position of the parties in a contract can be included within an annexure or a schedule. Like, say, for example, quantity of the products to be sold, the manner in which a purchase order is to be made, the form in which an invoice is to be raised. All these are aspects that can be included within an annexure or a schedule, because including this within the main body of the text only increases the time taken to understand the contract. With this, I would just bring about certain critical clauses that you might have to look into while going ahead of a contractual drafting. One of the most essential critical clause is that of the parties. How you describe the parties is very crucial, because with a small change in a spelling, the identification of the parties will become difficult. And as such, the description of the parties, that is their name of the parents, their existing age, and the place where they're residing, all of those have to be described and disclosed clearly in a contract. In case they are a company, then you will have to say that it is a private limited company, and also include certain descriptive factors. Like, say, for instance, every company has something called a corporate identification number within India. In certain other jurisdictions, they may have something like a registration number. So those registration numbers may have to be stated when you're describing a company, because tomorrow, in case there is going to be a change in name, the name is lost, but the registered number or the corporate identification number will not change in respect of a company. So it more or less remains the same. As such, it becomes easier to identify such entities. The second critical aspect that you need to look at is cost allocation. Now, generally, when a contract or a transaction is executed, there are certain costs that parties have to bear, especially if it is a contract relating to sale of goods. Who is to bear the cost of insurance? Who is to bear let us say, the cost of storage or transportation? Now, this has given across to various modes of contracts, like, say, free on board, and your cost, insurance, and freight contracts, and others. Now, as such, cost allocation determination in a contract is also extremely critical. The third part is the duration of the contract. Please note, specifying in express terms what is the duration or the term in which the contract is to be in operation is extremely crucial and critical to a contract. And sometimes there are certain clauses which extend beyond the duration of the contract. Like, say, for example, your non-compete clause, your confidentiality clause, and your non-disclosure clauses. These clauses are generally given an extended duration than that of the duration of the contract itself. So as such, it is extremely critical for you to draft it cautiously. Payment terms. Now, payment terms, you may ask me, why are we looking at it as a critical clause? Please note, a contract is executed only for the purpose of consideration. Everything else in a contract becomes immaterial if a payment clause is not drafted in constructive sense. Like, the payment could be monthly, annual, or on a weekly basis. And as such, description of the payment terms is quite crucial for understanding what is the consideration that is payable by each of the parties. The next critical aspect that comes across to deliberation is that of force majeure. The COVID-19 pandemic did create a particular premise of deliberation as to whether force majeure includes within it the COVID-19 pandemic crisis. Now, given that premise, there were few contracts which were held to be entitled to the relief of force majeure, and there were few that were not. That essentially is because in the manner in which the force majeure clause was drafted. Although COVID-19 pandemic was a scenario of an act of God which is beyond the control of the parties, there were few clauses that alone had the words pandemic introduced within it. And unless the term pandemic was introduced within it, the relief was not granted. But the government of India and certain other state governments did come out with a clarification in respect of government contracts alone, that the COVID-19 would be treated as a ground for force majeure. And only those contracts that fell within that purview of the clarification were given the release, whereas those of others were not given. Dispute settlement and arbitration. This is also another critical clause. One of the particular points to be noted with regard to dispute settlement and arbitration is that these are also called essentially something called a midnight clause. One of the reasons why it is called a midnight clause is by the time you finish the entire discussion, the team of lawyers come across, discuss a transaction, the parties come into discussing a transaction, and they enter into a dispute settlement and arbitration clause. What happens is by the time they reach out to deciding which is the venue for deliberation of some sort, it is almost late in the night. So as such, it is called a midnight clause. And generally, what do you do in the midnight? So generally, you are in a rush to go back to sleep, and often than not, contract actual drafters or those involved in drafting of contracts make a mistake in these clauses. They generally tend to use different words because they just want to be done with the work, they want to finish it, and they want to get back to their homes. So therefore a dispute settlement and arbitration clause is extremely crucially to be drafted. Rather than working it as a midnight clause, I would suggest that you work it out in a specific manner and carry out the drafting. Now, dispute settlement, you can choose courts as a mode of dispute settlement, arbitration as a mode of dispute settlement, mediation as a mode of dispute settlement, or a step-up arbitration clause which allows for you to include all forms of ADRs before finally going towards arbitration. Let me tell you, my friends, given that we have the MSME Act and the Commercial Codes Act, the role of arbitration has diminished drastically because arbitration is a very expensive process. If you're a small businessman or a particular person who is a small trader, a small time trader, in those circumstances, I will recommend that you do not add an arbitration clause to your agreement. Rather, you stick it out to the courts of particular jurisdictions. Like, say, for instance, in order for it to be a commercial dispute under the Commercial Codes Act, the transaction has to be of a minimum value of 3 lakh rupees as on today. So in those circumstances, if your transaction is between 3 to 15 lakhs, I would suggest that you can go ahead with enforceability of those transactions through the courts process itself, because commercial courts have made it more faster and more approachable for the matters to come into being listed, and it is more speedier than arbitration itself. Arbitration was earlier preferred because of the extensive pendency of cases, the security of transaction that it allows, and the immediate reactive processes that can be initiated once the arbitration process is put to frame. With the Commercial Codes Act, there is a time-bound decision making process that is introduced, and as such it is a much faster and a speedier mechanism for settlement of disputes. The next point comes across is to the termination clause. Now, under what circumstances can a contract be terminated? I have already discussed the $1 million comma case for you to understand what can go wrong if a termination clause is drafted in a poor manner. Just by mere addition of a comma, a punctuation mark, the entire term or duration of the contract, which was to be running for a period of 5 years and more, was reduced drastically to just a mere term of 1 year. That is one of the reasons why termination clauses need to be critically drafted. Confidentiality clauses, like I told you when we were discussing about duration, that there are certain contractual clauses that can extend beyond the terms of a contract. Beyond the term of a contract, in the sense that if a contract is for a period of 1 year, a confidentiality clause can be extended to a duration of 3 years also. And as such, confidentiality, the information that is to be confidential, have to be clearly defined in well withheld scope under the confidentiality clause. The next aspect comes to your non-compete clauses. Now, non-compete clauses, like I discussed earlier, that there are few transactions in which you cannot have a non-compete. Like, say, for example, if the relationship between the parties is an employer and an employee, in those circumstances you cannot come up with a non-compete clause preventing them from taking any employment with any competitor in the future. But if they are a partner to your business, if they are a shareholder in the same company as you are, in those circumstances you can enter into a non-compete contract with such shareholder or business partner, and it can be enforced. As the case of an employment, non-compete clauses, there are certain newer methods of ensuring that they do not jump to a competitor. One of the classic examples is that of a garden leave clause, which mandates that an employer has the right to keep the employee on bench, like I think as it popularly goes on for software employees. An employer has a right to keep the employee on bench for a minimum period of 1 to 3 months before he is relieved from his duties. So this is a particular aspect of mandatory notice period which can be enforced in order to ensure that employees are also kept hand in glove. With this, we move on to certain boilerplate clauses. Now, one of the reasons why I call them boilerplate clauses, or why it is popularly called boilerplate clauses, is because these are time and tested. So you do not draft these clauses specifically for a transaction. Rather, they are already drafted in an earlier contract. You just ensure that you extract it from the older document and insert it into a newer document. What are those? Sometimes the entire agreement is used as a boilerplate contract. This happens essentially in your standard form of contracts, like your insurance agreements, your software licensing agreements. I'm sure that during the course, you must have definitely installed at least one or more of the apps, including the browser app that you're using to view these videos. Now, if you look at it, the agreement or the terms and conditions are something that is already in existence. They do not draft it specifically because Mr. X or Rohit is installing the particular app. It is there because any user can download it and install it, and they will see this entire agreement as a boilerplate clause. Further assurances. Now, sometimes further assurances are used as boilerplate clauses. Generally, in respect of transfer of properties, further assurances are generally included, like, say, for example, the transfer of documentation such as your khata or your property tax receipts and certain other registrations as well. These are further assurances that are included as boilerplate clauses. Cost and expenses. Generally, the cost and expenses clause that relate to that all parties shall bear their respective costs and expenses. This is a boilerplate clause, and it can prove detrimental to you in case you have had an understanding with the other party that they are required to bear the cost. Like, say, for example, cost with regard to freight, transport, and certain other aspects. If they are going to be included in your contract, and you're going to have a boilerplate clause on cost and expenses, it is going to be contradictory to one another. Time is of essence. This is generally inserted into every single contract to make it abundantly clear that in case the contract is not performed within a particular time, the parties have the opportunity to repudiate the contract and go for a new vendor or some other person. Notices. Notices is also a boilerplate clause, which is generally a copy paste version. It gives you the name of the parties, the address, the phone number, and others. So please ensure that it is edited while you're inserting it into the contract. No partnership or no joint venture or relationship of parties. So sometimes when you're executing into a commercial transaction, like, say, for example, a distribution agreement, or it could be a vendor agreement, or it could be a sub-service contract. In those circumstances, there is a clause that is inserted in just to ensure that the contractual arrangement is not read as a partnership or as a joint venture between the parties. Liquidated damages. This is another boilerplate clause which has a restriction on the amount of damages that each of the parties can claim, and essentially liquidated damages as a boilerplate is included to the maximum of the total sum consideration of the contract. If you look at the inclusion of liquidated damages, it is still interpreted in terms of your section 74 of the Indian Contract Act, and even though if you stipulate certain X amount as liquidated damages, as per the Indian law, it is only up to that amount that can be given as liquidated damages and not otherwise. Specific performance. This is a clause which generally is included to state that the contract shall be specifically performed. But please note, if you're going to add liquidated damages and specific performance, there is going to be a conflict between the contract, because specific performance ensures that there cannot be any compensation. The contract has to be performed. Liquidated damages ensures that in case the contract is not performed, giving of consideration or a sum of money is equivalent to performance. Amendments. There is also a premise that boilerplate clauses can say that this agreement may be amended by way of such and such form or manner. Now, if you're entering into an amendment clause which is stricto sensu, that says that a particular contract to be amended has to be something in writing, in those circumstances, Such amendments have to be in the same form and manner as the clause provides for. Assignments, like I told you, contracts can also be assigned to another person. So sub-assignment or sub-licensing, these aspects need to be specifically provided. And if it is provided in a contract, they have to be carried out in the same form and manner. Waivers, generally boilerplate clauses says that no part or no clause of this contract can be waived. And as such, the waivers clause stipulates that unless the parties give in writing, a contract is not waived. Severability clause, which says that there are multiple facets in a contract. I think in the previous discussion we spoke about various parts of a deed. Now it may so happen that one part or one aspect of your contractual transaction becomes unlawful. Like say for instance, 2 months back in September 2022, we had a decision which was passed by the Karnataka High Court, which said that your bhang, which is actually sold, the bhang ki goli, which is sold especially during the time of Holi and other aspects in various parts of North and South India, is not a narcotic drug or a psychotropic substance. But whereas marijuana, ganja or weed is defined to be a narcotic drug or psychotropic substance. Now in those circumstances, please note the position of law as on today is with regard to supply of bhang is not illegal. Sale or purchase of bhang is not illegal. But let us say tomorrow the law changes. There is a change in law that is made, and by reason of which sale of bhang also becomes illegal or possession of bhang also becomes illegal. If you are entering into a contract for sale of bhang today and sale of certain other aspects like say filter paper and certain other points, tomorrow when the contract is avoided, okay, because of the change in law where sale of bhang is made illegal, you can still go ahead and enforce the particular contract for sale of the filter paper or certain other aspects. Now this is one of the particular premise which you need to keep in mind to understand what severability means. It means that two parts of a contract can be read as distinctive from one another. In such circumstance, if one part becomes unenforceable, the other part continues to be a valid contract by means of severance. Force majeure, we have already had a discussion in the previous instance as to why there is a requirement to draft the force majeure clause in a proper manner. Please do not ensure that it is a boilerplate clause. Try and modify the force majeure clause time and again when you are executing a contract. Confidentiality clause, it is also essential for you to describe what is the confidential information, because a confidentiality clause in respect of a pharma company or a pharma transaction cannot be the same as a confidentiality clause for, let us say, in respect of a software transaction or a SaaS based contract, that is software as a service based contract. Non-compete clauses, these are also boilerplate, but try and ensure that depending upon the nature of the parties and relationship of the parties, you ensure that the non-compete is drafted accordingly. Governing law clause. Now, sometimes governing laws require to be modified depending upon the place of business of the parties. Please ensure that you put a court which has competent jurisdiction to handle the matters and the laws as well. If there are two Indian parties, you cannot have a foreign law for implementation. You have to implement it as per laws of India only, even if you choose arbitration as a mode of dispute settlement. Jurisdiction, please ensure that the jurisdiction, like the governing law and the jurisdiction, go hand in hand. Like I mentioned earlier, please ensure that the jurisdiction clause is given to one of the places where the parties have their principal place of business. Mutual understanding of parties. Now this is also another boilerplate provision which says that the parties have a mutual understanding and which is included within the contract. Essentially, most boilerplate clauses may become immaterial because of the reason that the major contract itself provides for the sum and substance of these contracts. So few of these clauses, like let's say for example, further assurances, time is of essence, your mutual understanding of parties, these are things that need not be included also. Counterparts, like I told you earlier, that one contract can be executed in multiple parts, but all of them will be read as one single agreement itself, and that is where you have counterparts coming into place. Next, we move on to certain aspects or negotiating factors that have an impact on the drafting of a contract. Essentially, when you're looking at drafting of a contract, it is necessary to understand that a contract is drafted based on the negotiating factors that each party has. Now, what may be these negotiating factors? Uh, First thing is the project size and capacity of one of the parties. Now, if you are a large scale supplier or a large scale business, any person doing business with you will have a lesser of a bargaining factor, in the sense that your project or your business is so large that it will have not just one but several vendors. So therefore, you are in a higher negotiable capacity or have a higher negotiating power over the other counterpart in your contract. But however, look at the inverse of this. Now, if you are a large scale business, but you require a critical component which can be provided by only one vendor, and there is no other vendor who is competent enough to give you such other aspect, then the negotiating factor immediately tilts towards the smaller business. Even though, despite your large scale business aspect or your project size and capacity, merely because the component that you're trying to procure is a critical component, your negotiating factor immediately shifts. The next aspect is the manner in which you are carrying out the financing of your business. Now, the financing or the business model that you have, in case you are extended because of loans or other aspects, there might be certain limitations that you have to carry out in your business. Like, say, for instance, the lender might have put in certain restrictions on you from entering into certain kind of transactions. That kind of curbs your negotiating factor with other contracts that you are executing. Taxes. Now, the aspect of taxes also plays a crucial role in order to understand what is the negotiating factor that you have. Given the premise of your goods and service tax and certain other aspects, it quite becomes a necessary negotiable aspect as to the pricing of the product that you are trying to take across. Certain goods might be inclusive of the GST that you might have to discuss, but there may be certain things wherein a higher duty or a rate of duty is being imposed, which impacts your negotiating price. And as such, your price fixation becomes a challenge because of the variability in the taxing model that you try to take forward. Operating costs. Now, operating costs also have a huge impact on the manner in which you negotiate with either of the parties, because an increased operating cost wants you to ensure that there is a sufficient markup or price that is fixed at, and as such, your negotiating factor gets affected immensely by the operating costs or the standing costs that you have in your day-to-day business operations. The tenure of the contract and post-contractual life. Now, also the term of the contract is something that you might have to look into for understanding the negotiating factor. Now, if you are a business that looks at a long-term fixed stagnated revenue generation, then the tenure of the contract can be kept, is required essentially to be kept for a longer period of time. For example, power purchase agreements. Power purchase agreements are generally for a longer time period, and they are generally preferred for a minimum duration of 5 years or more, because the price fixation method is for a period of 5 years, and only if they execute a contract for a longer duration, they will be able to reap out the benefits in the long run, and not otherwise, because electricity price is subject to change depending upon the price fixed by the regulator. Now, if a power purchase agreement fixes a particular price fixation for the duration of the contract, then in those circumstances, there is an immense benefit that one or more of the parties avail. And also the seller of power is also to benefit because he has a continuous buyer, and as such, the negotiating factor is quite equally divided there. Similarly to it, any other contract, depending upon the tenure and the post-contractual life of such transaction, is something that determines a negotiating factor. Like, say, for instance, in the case of a construction contract, the post-contractual life, that is, the building has to be in existence for another duration of at least a minimum period of 30 to 45 years. And that is the post-contractual life of the building, which gives across a premise as to your negotiating factor. So as such, the vendor or the construction agency will have a higher negotiating capacity to ensure that quality products are utilized. And as such, the negotiating factor of the person who is receiving the services is quite reduced as against that of a construction agency, depending upon the choice and material that is sought to be used by either of the parties. It is pertinent to note that there may be certain other contracts that also impact your negotiating factor. The foremost being, in case you are a special purpose vehicle that has been incorporated for a specific purpose, then you will be bound by certain agreements like your shareholders agreement and loan agreements, whereby your objects can be limited to serve only the purpose of the SPV alone, and so that the purpose for which the SPV is formed is not deviated thereof. The second aspect that comes into premise is your operation and maintenance contracts. It so happens that having an operation and maintenance contract gives across to economies of scale, in the sense that you know what exactly your fixed cost is, and so that you don't have to worry about your operation and maintenance variations, because this is for a fixed term period and you are able to focus on more other important things. But having an operation and maintenance contract creates a limitation on your price negotiating strategy, because regardless of what price you negotiate for selling the particular product, your operation and maintenance contracts remains fixed and does not change. The next aspect that comes across is with regard to your tenancy. Now, the aspect of tenancy is something that you can take into consideration for discussing as to in the manner in which you can make use of your tenancy rights. Like, say for instance, if there is a clause that does not allow you to sublet or sublease your particular land, the additional space or storage that is there in your particular tenancy contract or any other particular aspect cannot be used for certain other purposes, thereby affecting your negotiating factor with certain other businesses or expansion of your activities. Certain other interconnected agreements also limit your negotiating factors. And utility agreements, especially those with regard to your electricity and certain other aspects, the limitation for purpose for which you can make use of such aspects, are all those aspects that have a hindrance on your negotiating factors. With this, we move on to the last leg of discussion, which is the aspect of financing agreements and its ability to affect or impact your negotiating factor. Now, financing agreements are generally executed with your financial institutions or non-banking financial companies who have the tendency to impose restrictions on the manner in which you do your business. Now, if there are certain clauses that restrict you from carrying on a particular activity or any other aspect of doing business, like say for instance recruiting a third person as a part of a management or anything of that sort, in those circumstances the financing agreements also impede your negotiating factor in any given contract. As such, it is pertinent to note that there may be a circumstance where other contracts have an impact on your negotiating factor, and a due diligence of your contractual management is utmost importance to understand your negotiating factor before going into a contract. With this, we come to an end of our discussion for today. And if there be any further queries, you are free to raise it on the NPTEL dashboard, or you can also choose to write to us alternatively. Thank you.